this morning. She had her own court appearance somewhere else and wasn't able to be here in person, but in speaking with her, she was comfortable with allowing him to plead to a disorderly conduct. I don't believe we've had any prior dealings with the plea in this case.
Okay. All right, Mr. King. So what I'm going to do, based on the information provided, the city is reducing it to disorderly conduct. It takes it out of the realm of domestic violence, which takes away the possibility for the escalating offenses. But, you know, word of caution, just be careful, because you see how easy it is to get into this area of domestic violence, and it never goes away for the rest of your life, and it just continues to hang over your head. So I will accept the amendment to disorderly conduct. How do you plead? All right. And then based on the information provided, I will enter the finding of guilt. And then we have, I'm gonna give you the sentence at one time. Then we have 21 TRD 02895, which is a driving under suspension. That's being amended to no driver's license, which keeps you from getting any points. And the window 10 is being dismissed. How do you plead to that charge? All right. So the 10 is dismissed. No driver's license moves from a $500 fine, cuts it in half to $250 plus costs. The disorderly conduct, based on the information provided, again, even though that's a first degree misdemeanor, it could be up to a $1,000 fine. Based on what I have in the complaint and the information provided, it'll be $100. You just go to the clerk's office and be careful going forward. Take care, sir. Oh, for the DV, $100 plus cost. Thank you. And you know what? I'm sorry, Ms. Johnson, because I meant to call you, but I will in this next one. 23 CRB 00002, January 1st of 2023. Is it Mikhail Ward? Is it Michael or Mikhail? Michael. All right, Mr. Ward, this is an old case, olding meaning that was earlier this year. Haven't seen you in a while. How's work going? Because I remember two of you were working together. How's that going?
They closed down our old job. We both work start. She just started at Amazon, and I'm gonna start next week.
At Amazon?
Yes,
Okay, so y'all keep jobs and together, huh?
We got a son on the way. He'll be here tomorrow.
All right. How's the relationship going?
It's fine.
Okay. All right. Madam Prosecutor?
Yeah, so in light of what Mr. Ward just shared, plus I went back and I reviewed how our office handled Ms. Kidd's case, who was also charged in connection with this. She was given a minor misdemeanor disorderly back in January, so considering we do have a child on the way, the relationship is doing better, it's been my practice to try and do the same unless there are some special considerations.
All right. So how do you plead to the disorderly conduct? All right. And so that's basically accepting the amendment that the city provided. And yours specifically is a minor misdemeanor, which means you don't face the possibility of jail time. It'll go on your record as a minor misdemeanor, not a first degree misdemeanor. So it puts you in a better position. The fine will be $150 plus cost. I see you posted a bond. So when you go to the clerk's office, they'll apply that. And if you are owed money back, they'll tell you how you get it. If you owe us money, we can give you time to pay. All right. Any questions? Be careful going forward. Good luck on your baby, okay? Samuel Binion. Good morning.
How you doing?
Good. 23 CRB 00440. Madam Prosecutor, how are we proceeding today?
We had initially, we were going to dismiss Mr. Binion's case, and we discovered after that the other person, the victim and his, was also charged. After reviewing this and having discussions with both parties, I'm going to go ahead with our earlier decision to dismiss this case. If anything, he was the lesser of the two parties involved anyway, and she filed a refusal to assist for him, and he's done the same for her. So I'll just continue with what we're going to do.
Ms. Johnson, anything to add on your end?
Actually, yes. I just want to get the record to reflect that this is not the first time Mr. Binion or Ms. Long has been here. This is the second time she has filed a refusal to assist form with Mr. Binion. We were stood on probation and terminated from that from the last incident when it was disorderly conduct and dismissed. I just want the court to be aware that this is an ongoing thing between these two.
And for the record, I will state this will be the last time that amendments and whatnot will be given for either one of them. Come back in this court again, fighting, that's it. Whatever it has, that's what you're gonna get.
Mr. Binion, how long have the two of you been together?
Too long.
What's that? What's too long? For some people, too long could be 2 months. For some, it could be 20 years. How long is too long for you and her?
Well, actually, a little over 2 years, but
You have children and everything?
one.
Okay. How old is your child?
He's
Approximately.
9.
Okay. All right.
9.
Okay. So what's going to change? You know, so you two will be not fighting.
We can't live together. She has. I'm not being funny. She has.
I don't doubt it. A lot of things going around with, you know, it wouldn't seem like it's major, but sometimes whatever it is, just mean the two of you don't click. You know what I'm saying?
Yeah, that's what I'm saying. She has. So clearly we can't live together.
Yeah.
So
because what's going to happen, honestly, you know, one day, this is one, first of all, easily it's not going to be dismissed, but more important than that, one day this fighting could escalate. You know, something, you could be having a major bad day and then she's having a bad day, and next thing you know, you do something that you'll regret for the rest of your life. So when Miss Johnson gets up and states that it's not your first time, that's serious, because you got to look at that like, man, what am I doing that I continue to jeopardize my future, her future, my child's future? You know, if this relationship is that toxic, if nothing else for your son, because let's say you never do it again, but let's say he witnesses this aggression and he turns out at 16, 17, 18 doing something that you're like, man, I would have never done that. I wouldn't have took it that far, but you don't know, you know what I mean? So you have to be an example to your son every single day of how to deal with relationship issues with people who may not agree with you, all that stuff.
Yeah, that's the only thing that I got out of it. Like, this is the second.
All right.
So I can't.
All right, because next time you're gonna be looking at doing some time.
Absolutely.
All right. Absolutely. All right. So the case will be dismissed. You're free to go. Take care. All right. Oh man, so what are we doing on these? Huh? They all resolved. What's this? So, but look. So generally speaking, he will come back. So he's got probation. Okay. Hey, didn't work out any of these deals. Yeah. I mean, I'm just saying. Nobody. Hey, he lost a step. Come on, bro. It's just 4. Do we have any bonds? Okay. All right, Michael Pritchett, come on up. Mr. Pritchett, good morning. Mr. Pritchett, quick question. How old are you now? 30. Okay, cool. Are you working currently? All right. So we have your cases resolved. I have all this information. Madam Prosecutor, go ahead.
Yeah, some of them were already worked out. The criminal trespasses and some disorderlies were worked out in the prior day. But there are 2 assault cases, a newer one and one from 21 that I need to speak to the officers on. They both involved officers. I did speak to Officer Robinson on the 21 case. He was straight from him. I spoke to Officer Mills, who was one of the 3 on the 3 assault charges, and he had conversations with Officer Paradise and Hollis, Detective Hollis. And I guess Mr. Pritchett has a history of liking to spit on them. So, but in this spitting, however, you know, he's aware, you know, communicable diseases that call it a felony. But so I'll reduce to just one assault, please to the one. I will dismiss the other 2 and go forward with the other pleas already.
Okay. So, Mr. Pritchett, you spoke with your attorney. So you understand these cases are resolved. You understand how they're resolved? Because what I'm gonna do is I'm gonna read them off and then we're gonna talk. So the cases that are gonna be dismissed: 22 CRB 00564, disorderly conduct, criminal trespass; 22 CRB 00735, possession of harmful intoxicants; 23 CRB 00291, controlled substance; 23 CRB 00340, criminal trespass; 23 CRB 00292, criminal trespass. And then we have the cases that are being resolved. So let me read those. I'm gonna start with the open container, 22 CRB 00640. How do you plead to that? Is it no contest based on what I have here? All right, I'll accept the no contest plea with a fine of guilt, as opposed to $1,000 fine, because a first degree misdemeanor could be $1,000. It'll be $50 plus cost. Sorry. All right. Disorderly conduct amended to a minor misdemeanor in 22 CRB 00777. How do you plead to that? Accept the no contest plea with a fine of guilt, $75 for the minor misdemeanor. 22 CRB 00826, minor misdemeanor, disorderly conduct. How you plead to that? $75 for that. Criminal trespass, 23 CRB 00298. How do you plead to that? All right. No, we have the other ones. This is the more recent one. So that's $75 plus cost. And then the last two are the assaults. The assaults are being amended to disorderly conduct, and everything else on the charge are being dismissed. So what I mean by that is 23 CRB 00470 from December 1st of 2023 had 3 assaults. It looks like you were going to enter a plea of no contest to one of those, with the rest being dismissed. Is that your understanding? How do you plead? No contest. All right, we do $100 plus costs on that. And then 21 CRB 00849, assault, disorderly conduct, obstruction of official business, and resisting arrest, back from 2021. That's going to be one charge of disorderly conduct, with the other charges being dismissed. How do you plead to that? All right. And that'll be $100 plus cost. All right. All right, so a couple of things, Mr. Pritchett. If you're looking to drive at some point, I mean, everybody is, I don't know what the status of your license is, but these fines that you have here, if you don't pay them or make an effort to pay them, they will end up blocking your license. So I just want you to keep that in mind. So at some point, do what you can to make this right. Counsel, you have something to say before I speak to Mr. Pritchett?
Mr. Pritchett is on probation with the county, and he is aware that these pleas could affect his probationary status.
Okay. Which judge are you on probation to?
I'm not sure.
You don't recall? How long has that been?
About 7 months, 8 months.
Okay. All right. What I just want to mention to you is all those charges sound crazy, right? Disorderly conduct, all that stuff. At some point, as you know, you just got to grab hold of your own situation in life and say, you know what, I want better for myself than to be dealing with these courts and judges and police. And what I would say is, Ms. McCullough stated that when you get into police, she said something about spitting. I wasn't there. I don't know all that stuff, but obviously that's unacceptable behavior. But most importantly, there are other ways to go against the police, orderly ways where you can be more effective than doing something like that. You could run into the wrong police officer who's having a bad day, and he's going to justify trying to hurt you. You see what I'm saying? So don't put yourself in that position. And I also want to say this: I appreciate the effort you made with you and I, because you and I had a deal with you coming back. You was a little late, And plus, you know, nobody around me believed that you was gonna come back, but I did. And I wasn't even playing. And I just want you to know that, you know, you can do whatever you want to do. And I believe in that. I believe in you, even though you're on probation downtown. Soon as that's over, or while that's over, you can say, well, you know what? This is a new day for me. Next year, I'm gonna get past this stuff. I'm done with the courts. I'm moving forward. And I'm telling you, man, at 30, regardless of your past, anything you want to do, you can do. And even if it includes going against police and changing how they act, it's a way to do it. It's a way to get your voice heard. It's a way to be, you know, a man about it. You don't have to be soft about it, but it's a way that you can do it so you don't end up in the system. So I just want to encourage you, just like you showed me that you can come back and you can be trusted, you know, prove it to yourself, because that's more important. You know, don't doubt yourself and your greatness and your ability going forward. All right. Try and take care of your fines and costs, because that's going to come back and hunt you. I would say this: if some point you say, you come back up here and say, judge or bailiffs, what can I do to work that off? Is there any community service I can do? We'll do that for you. All right. But other than that, go to the clerk's office. They can give you a printout so you at least know going into next year how much you owe East Cleveland, what all your situations are, and you know, do the best you can. All right. Take care. I would say, if you have any connections to give me paid, because my brother disrespecting the agreement we made. You know all the page. I was preparing the page. I told him, I said, dang, it's just not, man. It would have been the right thing for me to do. I would have put it in your pocket. I left it on your window, your windshield. You wouldn't have known I did it. All right, Michael Hollis. Mr. Hollis, coming up, 23 CRB 00501 from December 24th, 2023, alleging petty theft and obstruction of official business. The complaint is alleging that on that particular date, the 24th of December this year, you did remove items from the Dollar General without paying. And then they're alleging that you attempted to flee from officers. That is the obstruction of official business. It is the 28th. So you've been in jail for 4 days, approximately. All right. So your attorney wants to enter pleas of not guilty. So for any of the cases that I have here, again, I know I have some felonies. On the cases that I have, this is how I normally handle it. Domestic violences, we always have a bond because I got to make sure everybody's safe. Felonies, I have to set a bond. But on a case like this, when you've been sitting in jail for 4 days, I can let you out without having to pay any money, maintaining not guilty, so you can come back and deal with this case. But you got to promise me two things. One, that you're going to come back to court and that you're not going to do anything to disrespect me letting you out while I let you out. So like, for instance, your next court date is not going to be until January 11th. So no issues with Dollar General, nothing like that if I let you out. You understand all that? Can you agree to that? All right. So we're going to maintain not guilty today. I'm going to give you $1,000 personal bond. So you're not going to have to pay anything. Make sure you come back. We'll handle your case on January 11th at 2 p.m. Yes.
Do we have an address or something on him? Because when I spoke with him, he had no idea where he lived, the street or anything. Said he was with his mother. I asked him, how do you get home if you don't know what street you live on? But he couldn't answer that. But he has. I just wondered if the court had some address on him.
I do not. Go ahead. You have something to add, Detective?
So his booking.
I see that too.
His booking is out of town. I think it's Tennessee, Memphis, somewhere around there. He might be a flight there.
Well, let me say this. Since they're bringing that up, Mr. Hollis. Look. So, how old are you?
Oh,
All right, 37. So, and you're from Memphis?
yeah.
Okay.
I'm there.
How long you been up here? Okay. And who were you staying with friends or something like that?
No, my mom.
Okay, with your mom. Your mom lives up here? All right, this is what I'm going to suggest. Look, I mean, I'm not even questioning if you've been involved with the legal system in Memphis. All I want to say is this: petty theft and obstruction of official business. I don't feel comfortable leaving a young African-American young man in jail for days over that, just because I'm worried about you coming back. I'd rather show you that I can trust you to handle your business the way you're supposed to handle it. Because if you don't come back, even if you go back home, There's going to be a warrant that will someday pop up even down there. You'll be driving somewhere, you'll be kicking it, and you'll be like, oh man, I got this warrant in East Cleveland, Ohio. They'll put you in jail, they'll hold you for a week, they'll call up here, ask if we want to come get you. They'll spend 5 days making a decision whether they want to come get you. And if they decide to, that's another week or 2 weeks. You know what I'm saying? Your whole life can be messed up over dollar store stuff that we can easily resolve. So I say all that to say, the two gentlemen brought to my attention, it's risky for me to let you out of jail. I'd rather trust that you're going to come back and do the right thing. So I'm not going to hold you until January 11th. That's what, like 13 more days. I'd rather trust that you're going to come back. Now, I will say this. If you, Mr. Hollis, have decided to go home as a man, I'm asking you to do this. Come back up to this courthouse. You see all these brothers around. They're my bailiffs. Speak to one of them. Let them know, hey, I was in court. They'll remember you. I'm trying to go back home. Can we talk to the judge? Can I get before the judge today? Any of that stuff, just to show that you can keep your word. I really rather you just stay here and handle your business. But by chance, if you're trying to get back home, give me the respect as an African-American man trying to give you a break to come up here and talk to my bailiff so we can do it the right way. You understand? So I'm just saying, I don't know what goes down in Memphis, but I'm just telling you how I want our relationship to be. Even if we never see each other again, it's good to stand on integrity, right? So I'm gonna let you out. You have the court date in your hand. I'll see you on the 11th. If things change, make your way back up here to speak to my bailiffs. Or I'm telling you, these things don't go away. I'm telling you, they creep up on you when you least expect it, okay? But I'm not gonna have you sitting in jail for another 13 days on a petty theft from a dollar store, because I have more respect for you than that, okay? So you'll be released today, and I'm looking forward to seeing you on January 11th, right? All right, you can have a seat. You're welcome. Armani Harris Carter. Ms. Carter, 23 CRB 00503 is from December 28th. So that's today, basically. You haven't been in jail 24 hours, right? They're alleging that you committed an assault by striking a Miss Jordan. That is an assault. First degree misdemeanor, which means you could get up to a $1,000 fine and 6 months in jail. I will put here, or put on the record, the officer who charged this marked recklessly. We'll talk about it later, but the prosecutor knows there's a slight difference between, your regular assault and being reckless in assaulting someone. So we'll figure out what that means in specifying to your case shortly, okay? But as it stands right now, we're maintaining not guilty. How old are you, ma'am? 23. And who do you live with? You and your best friend? You have any children?
No.
What city do you live in? Are you working currently? Okay. I know you were present. Do you know what the two conditions of me giving you a bond are that I just mentioned, as they would apply to you? If I let you out without having to pay any money, what do I expect from you? What do you think? Show up to court. And as far as I have right here, not to get in any other fights or anything like that. Is this the fighting? Is that something I need to worry about? No. Okay. I mean, you don't want to let any beef or anything that's going on with somebody else cause you to be sitting in somebody's jail. So it's not worth it. It's not worth your freedom. I'm going to set your pretrial for January 11th at 2 p.m. And you're going to be let out on a personal bond, a $1,000 personal bond. And what I'm going to do for this case and the other two that I have coming up, I'm just going to put here my journal entry that I advised you and ordered you to have no contact with this young lady, okay? So don't call, text, DM, social media, none of that stuff. Just stay away, and we'll see you when you come back. Is that where the person works? The big? Okay. All right, so definitely, yeah, you can't go to that Papa John's because we don't want any issues there. But keep in mind, I mean, serious, 23, you said? Okay. Yeah, you don't want to be locked up, and I mean, seriously, whatever it is, it's not worth it, okay? You can have a seat. So speaking to the no contact order, because I have two cases coming up. When the court puts a no contact order on an assault case or especially a domestic violence case, What I always try to tell you all is that these cases could be resolved in any number of ways. You have a great attorney over here who may take it all the way to trial and may win your case. You have a prosecutor who cares enough to look into it. If you heard earlier, she may change the charge, reduce it, dismiss it. But what does not change is if I let anybody out on a bond and I give you a no contact order, every single time, I'm telling you, if you contact the person, you go there, you text and call them, prosecutor notifies me or Miss Johnson, and that's immediately 6 months in jail, because I look crazy now because somebody was at risk in a domestic violence or an assault. I let you out, told you not to go there, you went there. So when everything goes left, they're going to blame me. So when I trust you like that, ladies and gentlemen, lady and gentlemen, I just want to make sure you understand. No contact means no contact. I mean, seriously, cases get dismissed, but when they find out about the no contact, as soon as you hit the stand here, as soon as they arrest you, it's 6 months in jail. We don't even really talk about it. You know, I let you know there's no offense. I'm not offended. It's just the consequences of the agreement. All right. So I don't have to say that again. We already said it. Mr. Bell, come on up. Mr. Bell, how's your first name pronounced? Intumi. 23 CRB 00500. You're charged with domestic violence, a first-degree misdemeanor, where they're saying that you knowingly caused harm to Ms. Horton, using a pen, doing an argument. All right. That's a first-degree misdemeanor, which means you could get up to a $1,000 fine and 6 months in jail. Also, important about domestic violence, it's an escalating offense, which means if you are convicted of one or you plead guilty, the next time it's charged as a felony. It continues to get charged like that until you're facing mandatory jail time. So it never goes away from you. You've been in jail since, so 2 days, right? Is this where you live with this person?
Yes, sir.
All right. So part of the agreement of the bond is no contact. You heard that. And what we need to do is work with Ms. Johnson or the bailiffs to notify this young lady that you're going to be out. So even though I'm going to set a bond, we have to make sure we have contact with her before I let you out. Where are you going to go other than this place? Where else do you have to go? All right. Make sure you do that again, so you don't violate the no contact order. Ms. Johnson, you have anything to add for the record?
That's right. I just stick with the victim, Ms. Horton. Technically, she's going, from my understanding, she's going to put his necessities in a bag by the door so people come by with a police escort. Make sure you do go by with a police escort to retrieve those items. Any big items that he needs to get, she said that she would be willing to give to his brother, and then he can get from his brother at a later time.
Okay. All right. I'm glad Ms. Johnson brought that up. For you, Mr. Bell, we have another case, and the young lady back here, even though you don't live with the person, and you don't live at Papa John's, right? So we don't have to worry about that. If you have to get items from your home, you have to have a police escort. So make sure you, because that's another thing. People have gotten out of here and they're like, well, Judge, you said I can get my stuff, but they missed it. Then I said you have to have a police escort. So then they go to jail for 6 months. So she'll have all your essential items, and the big items, it seems like she's going to give them. Normally I'd say just leave them until we get this resolved, but it seems like she's working. She's going to work with your family to get you those. So no contact, not guilty today. You'll be back on January 8th at 9:30. All right. Any questions? All right. We'll see you. So you can have a seat. Thank you, Jay. That's for Mr. Bell. And then we have Janelle Lewis, 23 CRB 00504. Lewis. When did I lose like a while ago? Today? I just saw him. I don't even recognize. All right. 23 CRB 00504, domestic violence. Ms. McCullough.
Yes, President, before hold off on the ring, Mr. Lewis, at this time, this case is being reviewed for felony. We expect for a felony affidavit to be issued for him shortly.
All right, Mr. Lewis, you have a seat for a moment. We'll hold off on that and recall it. So you want us to recall that this afternoon, possibly? Because we have. Yes.
You won't be ready this afternoon.
Okay. Bernatez Bell. That was you. 23 CRA 00237. Mr. Bell, this is from April 4th of 2023. The charge is aggravated murder in violation of Ohio Revised Code 2903.01. The possible penalty for that charge is a felony of the first degree, where you're looking at least 10 to 11 years in prison and a $20,000 fine. However, with the aggravated added to the charge, that puts you in the position of a life in jail sentence. All right. The complaint states that on or about April 4th, 2023, in the city of East Cleveland, Mr. Bernatez Jones, and they have Alexander Bale Curry, did purposefully cause the death of Dominic Allen by shooting him in the back of the head by means of a firearm and fleeing immediately thereafter. You spoke with the defense attorney, correct? Counsel, on behalf of Mr. Bale Curry?
Yes, sir. At this time, Mr. Bell can be not guilty. Mr. Bell has retained his own counsel to represent him, and I would ask that this court continue this matter to give his counsel of choice the opportunity to come in and represent him in reference to this matter.
Okay, Mr. Bell, you spoke with an attorney? Not yet, but you want to retain an attorney for your own? Okay. So this is what I'll do. I'll walk you through this. So first of all, I'm not your attorney, obviously, you know that. I'm the judge. So at this point, you have this felony charge that if it's gonna be charged, it can't be handled in a municipal court, whether you understand that or not. That's what happens. You have a right to hire your own attorney. And with that, through that attorney, you have a right to request a probable cause hearing, and that attorney has a right to waive the hearing. What I could do is, if I continue the case so that you can contact an attorney, there is a bond that's set on you already. There's a bond they request, and we'll talk about that. So you will remain in custody on this bond unless you make the bond until we have the next hearing, which will likely be Tuesday or Wednesday. Again, the only other option, if you wanted to and you don't have to, this gentleman could walk you through the process that could lead you to being in a different location, the county jail, as opposed to East Cleveland's jail, sooner than Tuesday or Wednesday, but you don't have to do that. If you rather stand on, I want to hire my own attorney before I do anything, I understand that, and that's what you want to do. That's perfectly fine. Detective, you want to address the bond? Is that it?
Yes, Your Honor. Because of the death of Mr. Allen, we would like to have $1 million surety, Your Honor. He was looking for him right after the incident, and this happened in April of this year. And in 2 weeks, we couldn't find him, and we had to get the assistance from the United States Marshals, and they arrested him yesterday.
Okay.
Yesterday morning.
So what I'll do is,
So we asked for this because he may be another flight.
okay. So Mr. Bell, what I'm going to do is I'm going to set the preliminary hearing for January 2nd, which is Tuesday. And because he's hiring his own attorney, Mr. Davis won't be here. Once the attorney is notified, we can have the hearing. That's not a problem. We can have the hearing, or his attorney may speak with you about waiving or whatever those options are. So we'll play it by ear to give him a chance to have an attorney. Oh, we not. Oh, we're not here on the 2nd. That's the 3rd. It's the 3rd. I'm sorry. So that'd be the 3rd. So, but again, this will give you a chance to get an attorney. Now, here's the deal, though. If you get an attorney today, tomorrow, your attorney, obviously, for this type of case, is going to know what to do. He can contact the court. He can contact the detective, the prosecutor. He'll know how to navigate everything. So we still may have movement. Otherwise, we'll have a hearing on the 3rd.
Yeah.
All right.
What he'll do is sit in on downtown.
And the bond is set at $1 million. That's my normal bond for this type of charge anyway. So we'll leave it at that. All right. You can have a seat, sir.
Thank you, Your Honor.
You're welcome. Everything's done. All right. Thank you. Appreciate you both. Yes, sir. Yeah. So this is a rip. Yeah. Okay, I wonder is this the case that you're telling me about? I had this morning. I had it. What? Constitution of what? Did Davis agree to this? Mr. Davis, you had a chance to speak back with Mr. King?
Yeah,
You spoke with him since he's been back in?
yeah,
They're asking for restitution?
yeah,
You're agreeing to that?
yeah.
Mr. King, come on up. Mr. King, recalling 23 CRB 00476 that we had reduced to, a misdemeanor. The prosecutor brought this back up and there's an issue of restitution. You're okay with that?
Like I said, I just want to get it over with. So,
What's the restitution? What's the amount and what is it?
She hasn't received a estimate yet, so we can revisit that later when she brings in.
Okay.
I'll submit them to the probation department.
Do you know what the item is?
It was a dented door panel.
Okay, so here's the challenge. So what I can do is, car door panel. So here's the deal. Your attorney and you are on the record saying you're okay with restitution. You want to get it over with. This was reduced from domestic violence to a misdemeanor, $100 fine plus costs. I did not impose probation, right? But I am stating here through this signature that you've agreed to restitution. So at some point, what's going to happen is she's going to let the prosecutor know what that restitution is. You've agreed to take care of it. You understand that? That's the matter closed for me. Yes, counsel, go ahead.
And Judge, if the restitution is determined to be unreasonable, then I will request a restitution hearing at the station.
Say that again. If it's what?
If the restitution is determined to be unreasonable, then I will request a restitution hearing on this matter.
Okay, so what that means is this. Let's say the prosecutor comes back tomorrow and say, hey, we have the receipt, it's $25. And you're like, okay, cool, I'm done with it. That's fine. What if she comes back and says it's, $4,000? You can say, because I journalize what you're going to pay. You can say, you know what? I'd rather have a hearing. I want to see some proof. I want to dispute it. And that's what your attorney is talking about. All you have to do at that point, sir, because I don't want to keep this going on because I don't know how long this is going to take. It'll be on you to simply speak to my bailiffs. I'm not even going to make you put it in writing. I wouldn't normally say file a motion. Speak to one of these gentlemen and say, I had a case. It's about restitution. I need a hearing with the judge about restitution. And we'll do that for you. So what your attorney is asking me to do is provide the platform for you to speak about it as opposed to just own it. Because otherwise, all she had to do is pull this journal entry and sue you, go on your credit and all that stuff. Instead, you say, no, I want to go back before the judge because I want to talk about this amount. You got it? All right. All right, everyone. Thank you. But, you put the ball in his hand. No, so everybody's going to be. So, no point us entertaining it either. Yeah.
Housekeeping issue.
Yes.
I received word initially through Instagram, and then later I received a phone call from James Silverman, who is the grandson and victim of Robert Ropa, that he is now deceased. He currently has before the court case numbers 23 CRB 00048, 21 CRB 00391, 22 CRB 00490, and 23 CRB 00457, which are now abetted by them.
You know what? Madam Prosecutor, can you give me those numbers one more time? I'm writing it down.
23 CRB 00048, 21 CRB 00391, 22 CRB 00490, and 23 CRB 00457.
So there are 4 cases, 391-048-457 and 490.
And 391.
Yep, and 391 is 23,
21.
21. 048 is 20,
3.
23. So we have 23.
223.
222.
121, and 122.
There we go. You're right. All right. Thank you. So this afternoon we have a trial or two. What is it? Are you aware of Mr. Davis? We have a trial this afternoon.
Who? I will be when I grab the file.
So you'll be ready when you're ready. How many trials do we have this afternoon? Just the one?
Who is it?
Who is it? Is it a friend of mine?
That's iffy. 'Cause I don't
Who
know.
is it?